And activism arises when a judge allows their personal values, even deepest values, core concerns, broader perspectives on how the world works, and the depth and breadth of their empathy to influence decisions. Because isn't that bias? Who knows what these judges, and they have a lifetime appointment, and they get to impose their core concerns on us? This is a serious matter. And I think the American people understand it, because when you empower a judge to do these kind of things, you've given them control over you. You've given them the power to redefine marriage when the people of the state don't want to. And you have no recourse. They have a lifetime appointment. And some people say 9 judges can do that. Only 5, really. It only takes 5. And they meet and have tea, and they go to Europe and in the great salons of Europe, and they get these ideas about how to make America a better place, and they want to come back and get itching to just write it into some opinion somewhere. I would say that no drafter of the Constitution or any of the provisions in it at any point that those amendments were adopted would ever have imagined that a federal judge in California would declare that the people of California's decision to define marriage, as it has been since the founding of the Republic, as between a man and a woman, is unconstitutional. And make no mistake, when a judge says something is unconstitutional, this is not a little bitty matter. The American people, have no recourse except to pass a constitutional amendment. It says 2/3 of both House and the Senate and 3/4 of the state. They just make it so because they say it's so. There's nothing in the Constitution that defines marriage. Well, that's what we get. Right now, we've had battles over those kind of issues. They're the cause celeb of the day, but they become further issues in the future. Do you think maybe in the future it comes down to whether a judge can require the state to raise taxes? Will it require a state to provide insurance to everyone, or the federal government to do so? Because the Constitution somewhere says that everybody should have equal protection of the laws. That means everybody should have health insurance. We've got one nominee that President Obama has submitted, Mr. Lieu, who says everybody in America is entitled to welfare constitutionally. Presumably, if you filed a lawsuit in front of him, he would order the state to provide welfare to everybody, whether or not we could afford it or whether or not the legislature decides that's the right thing or not. This is what activism is. It's a serious matter. I want to take a few additional points to discuss that relate to matters that have been raised in the last day or so about this nomination, and try to be correct in what I say. I really want to be correct and fair. This nominee deserves fair treatment and accuracy, and we should try to achieve that in the Senate. And if I've said anything before or say anything now that's in error, I hope my colleagues will call that to my attention, and I'll be pleased to admit that I've made an error if I have and correct it. Likewise, I'm beginning to wonder, I've said this before, since nobody has corrected any significant matter that I've stated, they must be agreeing to it. One of our senators defended Ms. Kagan by insisting my arguments, that any arguments that she made as Solicitor General were made on behalf of her client, the United States, and should not be held against her. They suggest that her action as Solicitor General should therefore be immune from criticism. In other words, she didn't necessarily do what she thought ought to be done, but she had a duty to defend the law. Well, it misses the point about the Witt case, the important case that I talked about, in which I criticized her decisions as Solicitor General. The problem with Ms. Kagan's actions in the Witt case is she did not make all appropriate arguments in defense of her client, the United States. She declined to effectively represent her client, the United States. So what I want to say is that my colleagues were in error in their statements about this, because it wasn't that she made arguments to the court that she didn't believe in, and that somehow we're unfairly criticizing her for doing that. What I'm saying is that arguments she did not make that she was duty-bound to make to defend the law, and actions that she was duty-bound to take. It's been said that one of our colleagues said, this lawyer 101, that an attorney will take positions on behalf of a client even when the lawyer disagrees with them. Well, that's exactly right. An attorney does have a right to vigorously defend his or her client, but Ms. Kagan refused to do that. Her client was the United States of America. And when the Solicitor General of the United States stands before the United States Supreme Court, or any lawyer, as I had the privilege to do for 15 years, in the Department of Justice, stand up in a federal court, you know what they say? First thing they're asked, counsel, the judge will say, is the government ready? And the lawyer says, the United States is ready, Your Honor. The United States is ready. That's who the lawyer's client is, the United States of America. It's not her personal view of don't ask, don't tell. It's not President Obama's interest or idea of what should be don't ask, don't tell. Not his views. It's the United States of America. And how is the position, and what is the position that she was defending? The lawfully passed statutes of this Congress, signed by her former boss, President Clinton, passing the law, don't ask, don't tell, that was being challenged. So I'm of the view that in failing to properly defend that case, as I said earlier, she violated a direct, specific commitment she made to the Congress, and violated her duty, even if she hadn't made that commitment, as Solicitor General to defend the laws of the United States. Mr. President, I just want to share a few of those thoughts, and again challenge my colleagues to be accurate as they can in what they say, either for or against this nominee. She's entitled to fair treatment, but the matters are very serious. The American people want judges who are committed to their oath, and their oath says that they are to be impartial, that they are to do equal justice to the poor and the rich, that they are to serve under the Constitution and laws of the United States, not above it. And that's the commitment that we must have. And if we, and we should, as a Senate, never vote to confirm any judge, liberal activist or conservative activist, who, once they put on that robe, will not be impartial, will not provide equal justice, but will allow their personal biases, core beliefs, and prejudices to influence how they decide cases or their politics. That is a disqualifying factor. We must know that any nominee is committed to the ideal of impartial justice. I do not believe this nominee has ever had an opportunity to demonstrate that she would be unbiased in these circumstances, and indeed her record indicates that she has consistently allowed her personal feeling to override the law and her duty. Therefore, I oppose the nomination.